では、皆さん、こんにちは。ようこそお久しぶりですね。今度は、英語だけ話します。Um, today's topic is related designs in the US. This was a requested seminar, and today we'll be looking at the art issue that occurs with related designs in when related designs from Japan get filed in America. We'll talk about two special cases, which are a related design being invented within 6 months of the first design application. By first design, I mean like primary design. Well, actually, here I literally mean first design. We'll look at annual related designs. That's a different situation. That's a special case. We'll look at continuation practice in the United States. That's very different than divisional practice in Japan. And then we'll briefly look at US related cases because it is important to this topic. Unlike Japan, the United, and like most countries actually, the United States does not have a related design exception. That's pretty unique to Japan. Uh, we do have related case designations, but that relates to a completely unrelated concern. And therefore, when Japanese related design applications come to the United States, they might have art problems like obviousness or double patenting problems. Utility Tokyo applications have a pretty clear relationship with prior art. Okay. They've got 1 year of priority that can be claimed. There is a 1 year inventor grace period, and publication typically occurs at 18 months. On the other hand, design applications, isho, have a complicated relationship with prior art. So, for example, they only can claim 6 months of priority, but they still have the 1 year inventor grace period. And publication both in Japan and the United States can occur at grant, and therefore it's not as certain as 18 months, but grant is also typically less than 1 year. So the first issue we encounter is one of inventorship. And I kind of need to discuss um, utility applications for a second, because in those types of applications, we can strategize about the size of inventorship, right? The art becomes available on a predictable schedule. Few people in the company have expertise in an invention's technical area. And by that, I mean the inventorship is likely to overlap between a basic application and then the improvements to that application over time. It's likely to be, a couple of people's like major career path. But in design applications, the art availability is less predictable. Like we said, there's not automatic publication, it's based on grant. And because, we're working from a particular design, similar products can be designed by completely different inventors, right? The people that made the 2024 model of our car might be completely replaced and have a different team design the 2025 model of our car. This is unlike utility applications where, the design team would be similar. And so there is sometimes a tendency to be gracious with inventorship, right? There's this problem from the American perspective. Applications sometimes very graciously, very kindly, but unnecessarily include the CEO Toka, the inventor's boss, Toka, the summer intern, as inventors. Okay, these people may not actually be part of the inventive entity, but we want to flatter them, so we're going to include them. We don't want to do that in cases that might have related designs. Here, always, but especially here, The original inventive entity should be as accurate as possible. And the reason is that at the time of filing, there's no clear advantage to the inventive entity being big or small. It's possible to do these kinds of strategies for utility applications, but for a related design, we just don't know what kind of art or rejection we're going to have down the road. And so we don't know if we want a big or a small inventive entity yet. Therefore, our suggestion is to enforce the inventorship rules because it might be important for determining prior art, for example. Okay, much more so than a typical application, typical utility application, or typical design application, because related designs are known to have very similar prior art that may issue, in Japan, related designs are good for 10 years. So this could be something from like 8 years ago. And it'll be very difficult to overcome that when it comes to the United States. So let's talk about a special case. This is the related design within 6 months of the first design application. Sometimes inventors invent multiple related designs at approximately the same time. I don't actually know that this occurred this way, but probably the iPhone 16 and the iPhone 16 Pro were finished at approximately the same time. Okay. And they do have different designs, right? The 16 has two rear cameras. The 16 Pro has three rear cameras. So, for filing and design application, that two design applications that look exactly like these products, they will look different. In this case, if our related design is invented within 6 months of the first design application, we're going to want to combine them when we file the first US design application. Okay. Obviously, there might be situations where, the first Japanese design application gets filed and we don't know that there's going to be a related design, and a related design comes up 4 months later. Brian, what do we do now? In this case, just file the second design on its own. But if you can file them all in one application, please do so. The reason for the 6 month time frame is that the related design can only claim 6 months of priority. So if it's month 8, you can't include the related design and the original design in the same application. There are absolutely some risks associated with this. Not every applicant will want to do this. Notably, there is an increased likelihood of an election compared to a utility patent application, for example. In the US, multiple embodiments of a single inventive concept may be included in the same design application only if they are patentably indistinct. Okay. And this means that examiners are more likely to issue elections in design applications than in utility applications. Much more likely. And there's this additional complication that non-elected designs must be pursued in divisional applications or else they're dedicated to the public. So what might happen is that you will have to pay your US attorney for an election, and you will have to file this second design application because you don't want it to be dedicated to the public. And maybe you didn't want to file it maybe you eventually decide that we didn't want to file it after all. It's a risk. But examiners do not always issue restrictions. Okay, so here's this design application that had 52 embodiments that mostly focus on US states on bottle openers. They're illustrated in the corners of the slide. I apologize that it's a little bit hard to see, but these are taken from the actual application. And you can see not only are there 52 embodiments, but the figure numbers are quite large, right? This one is figure 226. This one's 241. Like there are a lot of designs in this application. Uh, a common question when I was giving this seminar is, this is Virginia. This is the state I live in. And of course, this is all of the contiguous United States. So it is possible to have them in one big application, right? And I don't know what your application will look like. So, maybe uh, you won't get a restriction because it looks like, it's very similar like this, or maybe you will get a restriction. I don't know. But this combined filing is your only opportunity to kind of increase the breadth of your disclosure. Okay. And that's basically what the goal of Japanese related designs is. And so you might as well take it. Otherwise, you're just filing separately, and there's nothing you can do about, related designs in the United States. And and that's the end of the story for those, right? This is your only way to try to obtain that similar scope of protection. We have another special case for annual related designs. Brian, what's an annual related design? This might be something like a car or mobile phone model, right? So iPhone 16 comes out in one year, the next year is iPhone 17. It looks kind of similar, but it has a smaller bezel. Okay. Here, there's a unique issue compared to the previous one because the first design can be applied as prior art after 1 year, right? You only have a 1 year grace period. And therefore, to obtain that, each related design should be filed in Japan no more than 1 year after the immediately preceding design was filed in Japan. I'm assuming that the uh, products get designed in a particular direction over time. There might be circumstances where, the design goes in one direction and then, after like year one, year two, year three, and then they kind of switch and branch off in a different direction from the original design. It goes year four, year five, year six. And, maybe we don't care about some of the prior art because it's a different design. Yeah, there's going to be, this is complicated stuff. I'm assuming it's linear. So you need to file it within 1 year because you want to obtain the grace period over the most similar design. After 2 years, we don't want to boss our clients around, but like, part of our job is advising our clients in how to protect their intellectual product or intellectual property. Here, we want to suggest that applicants change their designs more substantially after 2 years, right? Because from year zero, we've got, I'm sorry, from year one, we've got the original design. And after that, we've got the grace period back to that. And then the subsequent year, now that first design is available as prior art, and we need to overcome that more aggressively, perhaps. All right, that was another special case. Let's talk about continuation practice. This is your best opportunity to protect related designs in the United States. The big difference is that US design patent applications can cover partial designs, much more so than in Japan. It's much less strict than Japanese partial designs. The people that have seen this seminar are all shocked about how broad US design patents can be. And as a result of this big difference in the United States to protect related designs, we want to file continuation applications based on a partial design of the most similar family member. Okay, I know you already have questions. Don't worry, we've got some slides coming up that have like pictures of it, have examples on them. Here, continuations of the first design are very important because no family member can be used as prior art, right? That's the original application. But you'll probably want app continuations of all family members as the designs evolve over time. Okay, this can be very expensive. I mean, in relative terms. In absolute terms, design applications are much less expensive than utility applications. They can provide a very powerful scope of protection. And so they're actually relatively inexpensive. And it's very affordable to have multiple continuations. And that's what a lot of American applicants, that's what savvy American applicants, or even foreign applicants, uh, I guess American patentees would be the way to phrase that. That's what they do. In fact, there's a saying among US design patent attorneys that prosecution does not even begin until the allowance of the first design patent. Why would we say that? Well, we've got this design that's all in solid lines. It gets allowed very quickly. And then we start looking at, okay, well, have we learned anything from the manufacturing process where we might not want something to look a certain way? Have we learned anything from our competitors? Have we figured out what our new design is going to look like? All these different things, because the real prosecution, the real value of obtaining these is in the continuations. That first one is usually just, we have to get something on file. We'll claim something narrow. We're not going to worry about the scope. So for explanatory purposes, we're going to set it up in the context of annual designs like cars or mobile phones or anything else like that. But this does apply to any related design. It's just as true for, my inventors who say, oh, I've got, 5 applications on the same day. We still might want this kind of continuation practice, especially as we move forward in time. In fact, that's the whole point is we have to make decisions today based on what might happen in year 2 or year 3 or year 9, and this is how you do that. So in this figure, we've got um, our timeline on the left side. We see 2025, 2026, 2027. We also have this product development timeline. So we've got our 2025 product, our 2026 product, and our 2027 product. Our products are in blue. We've got assorted applications that are filed. These are probably our original um, Japanese and American design applications. A, B, C. You can see each of these corresponds directly to a product. But where it gets fancy is that we also have these American specific continuation applications shown in orange, or shown in red, actually. And that's what these orange lines are showing, is that these products can be covered by these US specific continuation applications. And again, we're going to have some pictures, so don't worry too much. But, this 2027 product might be covered here. We don't know. Maybe it's covered by application B prime here. Maybe it's covered by application A double prime here. All right, so what does this look like? Brian, help me understand. Okay, let's say these are our products. 2025, 2026, 2027. I told you that each product's going to have a corresponding application in black. Here's application A for 2025. Not a surprise. Let's look at 2026. We've got our 2026 product here. Now we're going to file a continuation, a US specific continuation of application A. We don't have, this is the related design from our point of view. We don't have something that's specifically like the related design in Japan. So you can see, this part of the figure matches this part of this figure, or it's supposed to, of the figure here. But because we don't have the triangle up here, we have to put this in dashed lines. And again, we're going to have we're going to have an application that looks just like the actual product. This is our related design in Japan. This is our new US filing. It's a separate filing in the United States. Okay, here's our 2027 product. Now, we've got these two um, horizontal lines that we're protecting with our second continuation application of in the A series of figures. This one's obviously very broad. You might not get this patent. This might be too broad. But that's what we're trying to do is keep this as broad enough based on its original priority date to cover this product as well. We're also considering filing a continuation of application B. Okay, right? This top portion looks the same. And so, this one, maybe we can't get application A double prime, but we can get application B prime. We can get this one because there's so much that's in solid lines. And of course, we'll have our new filing for this particular product. That's what I mean by partial designs in the United States, right? Of course, you have partial designs in Japan, but for us, it's much, much broader. This also begs the question of double patenting, because if you're filing these continuation applications, a double patenting rejection will probably issue. There's a lot of examiners that issue double patenting rejections on continuations just as a matter of course. Applicants don't always appeal those. They typically don't, at least not in pharmaceuticals. And therefore, people file terminal disclaimers to overcome them. In pharmaceuticals, people are a little bit more reluctant to file terminal disclaimers. Um, of course, this only applies if there's no election. If there is an election, then there's no double patenting rejection. So there's no terminal disclaimer. Under the Japanese Design Act, Article 22, the principal design and the related designs may not be transferred independently. This prohibition on independent transfer is also a major effect of filing a terminal disclaimer in the United States. There are other things as well. For example, it links the prosecution histories. But this is a big deal. So if you already know that you have a related design in Japan, and you already know that you can't transfer them independently, and you're okay with that, then when this related design application enters the United States, for example, in a continuation form, not necessarily the related design application itself, but an application that covers the related design, like one of these continuations, you have already accepted, at least in Japan, this prohibition on independent transfer. And so you might be more willing to accept this limitation in the United States and therefore be more willing to file a terminal disclaimer. Okay, like I mentioned, there are other detriments to terminal disclaimers, like linking prosecution history and reducing your patent term, but still to streamline prosecution, which is a major component of successful design prosecution, an applicant might file a terminal disclaimer at the time of filing the U.S. related design application. Okay. When you tell your U.S. attorney, I want to file application A prime, I've got my 2026 model, you can tell them, just go ahead and file this terminal disclaimer. I don't want in-office action. The terminal disclaimer might be unnecessary, but it might reduce, prosecution time. And to some applicants, that's a big deal. I have to discuss US related cases. This is not going to seem related to the rest of the seminar, but you need to know this. The US does not have an affirmative benefit, for example, increasing confidence in infringement to our related cases, okay? In Japan, there's this benefit to related designs. That's not what our related cases are about. Our related cases concerns protecting applicant or patentees, really, from negative outcomes. So the question I get every time is, Brian, okay, is this Are these American related cases similar to Japanese related design applications? Or is this just somehow a similar name? Like, why are you telling us about this? If the applicant knows they have a related design, then they probably have a US related case. Okay. I don't know your specific facts, but probably. And in that case, you should almost certainly be filing related case statements. Okay, Brian, what's a related case statement? They're like information disclosure statements. They're a form of information disclosure. But the important thing is there's no USPTO form. Okay. Each law firm will have their own form. Maybe some don't even have a form. Um, but they all look a little bit different typically. The point of these statements is to prevent one family member patent from being invalidated when another of the family members is invalidated, right? You can start, like, if you can knock out one application in a litigation, sorry, one patent in a litigation, you can start invalidating other patents in the family that might be involved in the litigation. Um, I typically get questions about when this occurs and why the USPTO does this. Let me be clear. The USPTO is not going to invalidate a patent because of a failure to file a related case statement, as far as I know. Rather, in litigation, when a court invalidates a first member of the family due to inequitable conduct, a second member can be invalidated due to failure to file the statement. That's what we're talking about, is issued patents in litigation, accusations of inequitable conduct in one during one prosecution spilling over into the second. That's what these related case statements are about. And you should be filing them when you have continuations, for example, or related cases, related designs. So here's what we discussed today. We talked about this art issue that arises because, we don't have, the Americans don't have this exception that exists at the JPO. And here our advice is to accurately identify your inventive entity, right? Don't include this intern, don't include the CEO unless they actually helped invent it. In the special case of a related design within 6 months of the first design application, we want to file them together in the United States if possible. It's not going to be a good solution for every applicant, but that's your best and only opportunity to try to get a scope of protection similar to Japan. We've got another special case of annual related designs. Here we want to file related designs within 1 year of the preceding design, again, assuming that our designs evolve linearly and they're not kind of, going, having some sort of retro one where we branch off into a different direction. We want to suggest that our second and subsequent related designs should be more different than our original design because now our original design can be applied as prior art. In order to really achieve similar scopes of protection, we want to be aggressive with partial designs. We want to file many of these applications. Um, and we want to file related case statements. That's just more IDS type work. This is how you can contact me. Thank you very much for your time. Um, that concludes it. Thank you very much.